SJC-13287, James J. Reagan, and another V. Commissioner of Revenue.
Attorney Jones, good morning.
Good morning, Your Honors. May it please the Court, I'm Richard Jones, here with Caroline Kupiak for the appellants, the Reagans, in this matter. There are two issues in this appeal. The first issue, the primary issue, involves Chapter 121A, which is a regime that authorizes private entities to invest in and to carry out urban redevelopment projects in blighted areas. Owners of 121A projects must pay a special excise, which is measured by their property value and by their gross income. But then, they are exempt from all other Massachusetts taxes. Specifically, Section 18C says that project owners are exempt from the payment of any tax, excise, or assessment to or for the Commonwealth on account of a project. Despite the clear and broad language, the Commissioner argues that this statute should mean something different than what it says. The Commissioner says or argues that the exemption should not apply to capital gains, income tax on capital gains from the sale of a 121A property. The Commissioner is incorrect. The statute means exactly what it says, that other than the special excise, there can be no Massachusetts tax on account of a project. The exemption statute.
Well, let's just actually look at the words of 18C. It says, in consideration of the exemption, you will pay the 121A tax, right? So it's a quid pro quo, right?
That's right.
Okay.
That's
so
correct.
So it's not just tax exemption, there's a quid pro quo.
That's 100% right, and that's right. So they paid a special excises, and then because of that, they're exempt from all other taxes, and there's no dispute here that the special excise taxes were paid all along, and these were qualified 121A projects and owners.
So I understand that you and DOR have a difference of opinion on capital gains not being included in 18C subparagraph F, but isn't on account of ambiguous? And if it is ambiguous, aren't all the tools of interpretation against you, whether against the grantee, the party with the exemption has to show that they're entitled to the exemption? This is the entity, the agency involved in interpreting the tax code. Why, if on account of is ambiguous, aren't all the tools against you?
Your Honor, I think that's the one thing that is actually not ambiguous. The sale of a 121A project, these project owners, they carried on these projects for 30, 35, 38 years, and then they sold the projects. What was the gain on account of? It was on account of the project. I don't even think the appellate tax board.
I wonder if it was on account of the project. So the project is defined, right, in the statute, right? And the project consists of any undertaking consisting of the construction, right? So this capital gain does not relate to the construction. And then it's any undertaking consisting of the operation, and the capital gain is not consisting of the operation or the maintenance.
Excuse me. Your Honor, yeah, of course, capital gains or sale of a project is not part of the definition of project. The definition of project tells you what a project is. What is a project? It was the undertakings and the projects that were carried out in the South End and Kenmore Square in the West End.
Right, and the sale of the urban development is not the project. It's the exit plan.
I guess what I'm saying is the relevant question here, there's no dispute as to what the project is. The relevant question isn't what the project. The relevant question really may be what was done on account of the project. Those are the words in the statute, so that's what we ask.
Right, but it's on account of the project. And so while you might not think my question is relevant, I do. And I guess I wonder whether the project defines the scope of the exemption. So the project consists of the construction, the operation, and the maintenance of the urban development.
Correct.
And you've conceded, as I think you must, that the capital gain has not to do with the construction, the operation, and maintenance. So the ambiguity in the statute may perhaps not arise on account of, but on account of what? Is it on account of the project?
Well, so I have to go back to the statute, Your Honor.
Yes, of course.
And the statute says that the exemption applies to tax that arises, capital gains tax, what have you, that arises on account of a project. What was done on account of a project? And that would be the gain, the tax from selling a project is clearly on account of a project. What you might look at, Your Honor.
But can you explain that? Can you explain
Sure.
to me why the capital gain is on account of the construction, the operation, and maintenance of the urban development?
Well, I think the way the statute would ask you to phrase it is, did the tax that we're looking to exempt arise on account of a project? So you don't define a thing based on what you can do with that thing.
But wasn't the project complete when it was built and running and they were maintaining it? Project over, right?
Well, no, the project still existed. It still
But it
exists.
was over. I mean, you weren't doing anything.
It wasn't constructed, is that what you mean?
Project is to get rid of blight. If you tax the end result, the whole purpose of this is to build a building in a blighted area to fix the blight, right? And you're going to discourage fixing the blight if you can't sell the building at the end of the day, right? That's your strongest argument.
Well, yes, Your Honor. So these projects, I'm sorry.
Again, the purpose of 121A is to get a building built that eliminates blight, right?
Right.
If you can't sell that building, I'm not sure how that's going to work. If you can't sell it without converting into a fully taxable entity, haven't we defeated the very purpose of the statute?
Well, I think that's right, Your Honor. I think the legislature, in fact, anticipated, acknowledged, and expected that projects would be sold even before the end of the project term.
What happens when it's sold to? I understand like a 40B project keeps going, but what was this? What did this building do?
So it's a very involved process. There's contracts with the city of Boston. Right. And so you get these approvals. It has to be approved as a blighted area. There was construction, for example. I think it was the Blackstone construction project was in an abandoned building. They created a number of units, 130 units, and by contract they were provided and maintained for affordable housing, disabled housing.
When that building is sold, does the new owner? What happens to the new owner? Does the new owner keep getting a tax benefit from? So does that all keep going? It's not like the project blows up and disappears.
The project could end. You get to the end of the 40-year term, the project could end, and there's no more restricted use, and the owner or the new owner could do whatever they want with it, or it could be sold to a new owner with no restrictions, and then the project and the restricted use ends.
But are there ongoing tax benefits? I'm trying to understand. I don't fully get this. After it's sold, does it continue to be a 121A project that someone else is getting tax benefits from up to that 40-year period?
It can be. In this case, it was. And these sales are subject to the approval, in this case, of the city of Boston. And exactly what happened here in 2012 is the new owners came in.
Does that help you answer Justice Wendland's question, which is, okay, it doesn't say sale, but the project is continually, even after its sale, right? Does that address?
Right, so I understand Your Honor is getting at the timing question, I think, of the project, which is a little bit separate, but that goes to if there's a separate issue that came up. If we are no longer carrying on the project, what the board said below, this part the board, I think, was correct, it says thereafter, if we're an owner and then we sell the project or our term ends, Stuff we do after the fact isn't exempt. We're no longer doing things on account of the project. But one of the issues the board, we agree with the board, stuff done afterwards, and it uses the word thereafter or a later sale, but that wasn't what happened here. This was a gain where the tax is at issue that arose at the moment that the sale occurred. And at that time,
Do you know if this is a new interpretation by the commissioner?
to my knowledge, yes. Since 1965,
And I'll
Section 18.
I'll ask the other counsel the same question, but what's your understanding of the issue?
Could you just repeat the question? I'm sorry.
I'm going to ask opposing counsel the same question, but what's your interpretation, or what's your knowledge as far as whether this is a new interpretation of 18C?
What I can say is, and I think opposing counsel would say that since 1965, I've never seen this issue come up. I've never seen the department take this position where it was litigated.
What about Rule 94-7?
94-7 was not about exemptions, and that's important. So there's a letter ruling that was issued in 1994, and the question in that letter ruling was whether the gain from a sale, or the gross receipts actually, from the sale of a project is subject to the special excise. The special excise is under 121A. Now, the answer was no, because the special excise is defined narrowly, specifically, it's tailored, and it only includes gross rents, does not include capital gains. So you read that decision, and every single line of the decision talks about special excise, not one mention about the exemptions. The reason the commissioner has cited that case is the very last line. There's three sentences in the conclusion. The first two sentences are perfectly in line with what I just said. The last sentence says, kind of out of nowhere, and because it's not subject to the special excise, that it would be, you'd pay tax under 62 or 63. And that was an error. That was just, it was a mistake. There was no explanation and no mention of the exemption statute. It had nothing to do with any of the analysis. To make that statement, you'd have to at least acknowledge that there's this very broad exemption statute, and it seems as though the author of that opinion wrote that line without realizing the exemption statutes were there because the ruling wasn't about the exemption statute. So I don't believe that ruling.
Could I follow up on Justice Gaziano's question, though? 121A has been in existence how long? The statute's 65. It's a product of the 1960s, right? So I take it there have been a lot of buildings sold. We have no tax cases on this issue? This is the first time this has come up?
That's right, Your Honor. And
is that why you
and now we have two amicus briefs filed by Pioneer Legal and New England Law who are alarmed by the position. But you're right, I don't think this has ever come up. And then we have to ask, what was the legislator's intent?
Can I just pause you there? It's never come up in connection with the partnership?
I don't think it's come up in connection with the corporation
That's
either.
my next question.
Yeah.
So corporations haven't had this capital gain issue, to your knowledge, the entire time. Is that because they usually keep the urban development for the full 15/40 years?
I wish I could say I knew, but I can say under the corporate statute.
Have you looked?
To see if there's any controversy.
To see if there's a similarly situated, like your client, where there has been a sale, where the treatment of the capital gain is at issue.
So I can say, based on my knowledge, through my client, I can say that my client has told us that no capital gain was ever paid with past projects on sales, and it got picked up this time. And so they think that's...
Talking about your client sales, right?
My client said, right, it's not evidence that was submitted. I'm being asked for what I know about, and so I can just tell you that.
Okay.
And so
can I ask one last factual question? It seems like it's a small number. What was the tax with, if it were tax exempt, and what was it with the capital gains? What was the difference? It was $130,000 difference. Is that right?
Well,
it
yeah.
Seems
so,
like a
Your
small
Honor,
number.
This particular case is one of many. There were a number of partners of these three partnerships. This is the one that went forward. So we're talking in this case about his own distributed share.
It's only his share.
This is only his share. So the numbers are bigger.
Do we know what the overall number for the sale of the building was?
I
I'm
can't.
just trying to understand what the tax consequence of this for that whole building was. Because that may relate to whether you're going to discourage fixing blight if the number differential is big.
Yeah, it's in the briefs, and I cannot recall the numbers. I mean, there were gains on these projects when they were purchased in 1975 through now.
The answer to that question, though, is going to depend on what the basis is, right?
That's right. And thank you, Your Honor. There is a second issue in this case, and it is raised in the alternative, but although we won't have a lot of time to discuss it, it's very, very important. And the reason why is, even though it's in the alternative, it cries out for this court's attention, no matter what you rule on the primary issue, because this decision below erroneously eviscerates the statute. What they essentially do below is they treat the 121A partnerships as if they were subject to Chapter 62. The basis gets adjusted like federally if you're subject to Chapter 62. But if you're not, because you're a 121A entity, which they were all these years, the depreciation deductions could be taken, they are not allowed to take a depreciation deduction by statute, by clear statute under 62, by not being subject to tax under 62, and the DeMarco case, an earlier ATB case, made that patently clear. So what happened on the basis issue is the court said, well, you chose to be a 121A entity, you didn't have to be that, so we're going to tax you as if you were. Well, that's just simply not permissible. You have to take the facts as they are and not alternative facts as what they could be. And so that's an issue we encourage the court to look at. And just in terms of the legislative...
We don't answer that question, though, if we decide the first issue in your favor, right? We don't have to address the second issue if you win on the first issue.
That's right. That's right. And we only ask this court might be interested in looking at it so that the decision on the basis issue below isn't left as standing law at the Appellate Tax Board. That's that question.
What were you going to say about the legislative intent?
Thank you, Your Honor. So with the board's decision was largely based on this timing question, and as we said, we think the timing was that they were exempt when they sold the property. But to the extent that is ambiguous, right? And as I said, I don't think the on account of is ambiguous because there was no other activities conducted by these partnerships. It could only be on one account. But with regard to the timing question, the legislative intent is where you would look. And, you know, this court says you have to consider interpreting the statute in connection with the intent and the cause of the enactment and the main object to be accomplished. Well, the intent for 121A is uniquely clear. Section 2 is a very long declaration of its intent and purpose. Public exigency exists, a menace to blighted areas, and that urban blight cannot be dealt with effectively by regulatory process or ordinary operations of private enterprise without the aids provided here. And so the legislature intended and did intend to provide extraordinary incentives to bring private capital into blighted areas. So that was by clear design when they made the statute very broad. That statute that has no carve-out for capital gains when you sell a project.
But it does, you know, I guess here's my problem with the broad statutory language and how that favors or disfavors your client. If I sell your 39, 11 months and 28 days, I, under your theory, have the exemption for the capital gain. If I sell at year 40 and 1 day,
yeah,
I don't.
That's right. I think it's...
And so I guess what is your best argument that this additional incentive for private investment in urban development is required if 1 day difference gives you a tax on the capital gain and, you know, or not?
It's very interesting. I actually want to backtrack slightly. If you sell it 1 day after, right, I'm not exactly sure that's not exempt. I kind of set it up because it's not our facts.
3
right,
days,
because it's
whatever.
still on account of a project,
Yeah.
right? And so it still might be exempt. But even if there were that kind of cliff, the legislature considered that people would, the 40-year term, which was at issue here, that is the maximum. You're not allowed to do that. But the towns may want you to do that. So they may encourage you to sell to someone and they can renew their term, which is what happened here. One was about to expire, got renewed by the city of Boston with the new owner for 38 years, right? So but the legislature has a provision, section 11, it contemplates exactly this. It says you may sell during the project term, and when you do that, the city of Boston or the city involved has the right to approval, and this is how the transfers of restrictions and rights would go. So they understood that that would happen, and it turns out to be quite beneficial here for the city of Boston. So, you know, there wouldn't have been any intent to discourage these sales, and with 40 being the maximum period, it might have been well understood that they wanted or expected turnover to happen before the end of the term.
But only if they restricted the turnover to somebody who was going to continue the urban development.
Well,
Did they do that?
Right. So there could be sales to someone who is not continuing the development.
Right.
And that might be in the city's interest too, again, subject to the city approval. So it wasn't that the legislature had any intent to discourage these sales. They seemed like they contemplated them. And then they left it to the city to, you know, make those discretionary decisions as to what's good. Maybe they didn't want the project to continue in the city or what's not. But I think that's where the intention was. The other thing, the last thing I'd say is, if you look at what the incentive, the extraordinary incentive the commissioner was trying, the legislature was trying to give here, we have to remember that there's a special excise already, right? And the special excise is, in this case, it was 10 or 15% of gross revenue, that was the rents, right? Compare that to the personal income tax rate, which is now 5%, and for all these years, it was between 5 and 6. This special excise was a lot higher on the income tax side. They pay 1% of the value on property. Where is this extraordinary incentive, if not for the gain for all of the revitalization of a blighted area that gets sold at the end of the project? Where is that extraordinary incentive? And I referred to the amicus briefs that were filed that touch on that as well.
Okay, thank you very much.
Thank you.
Okay, Attorney De La Foscade Condon.
Good morning, Céline De La Foscade Condon for the Massachusetts Department of Revenue. May it please the court. So actually, I would like to start by answering the question of Justice Kafker.
Can I interrupt you and ask
Sure.
you to answer your counsel's last question? Where was the incentive?
So that's going to also Justice Kafker.
Excellent. So let's do it.
So here we were talking about three buildings, residential apartment buildings that were pretty large. And the incentive was tax-free rental income almost for 40 years. So when you think of like 121A project,
Are
The
these,
rental income was what was taxed.
it's that's what is used to calculate the excise tax. But when you think about it, there's no income tax on the revenues that the partners are receiving, right? That's the exemption. So for 40 years,
hold
they
on a
do
second,
not,
but was this like a 40B project? Is this a low-income housing building?
it is a low-income housing
So,
project.
we've got someone building a low-income housing project in a blighted area, just what we want the statute to do, right? So they're getting those tax benefits, which are limited. This is not, they're not making a killing on this kind of building a low-income housing project in a blighted area. Again, that's what the legislature wanted to encourage. So the one thing where there's potentially, then we're going to convert it into a for-profit building at the end for the sale. I don't know. It just seems completely counterintuitive to the whole purpose of the statute to me.
Well, I would disagree with you, Justice Kafker. As I said, having income for 40 years that is almost tax-free, it is a huge incentive. Also, you have to think of what 120 projects you have. I mean, the Prudential Center is a 121A project. So when you think about, the rental income on the Prudential Center, which is tax-free for 40 years, it's a huge benefit. And here,
I thought that the taxes were on the rental income.
so the exemption that's provided under 121A is like no personal or real property tax on account of the project. So during the time that they have the project, and partners being, here since we're talking about partnership, it's a flow-through, the partners are not being taxed on the revenues that are being received from the partnership.
Did you say, though, a property tax? No
Correct.
property tax.
Correct. There's no
Okay.
property tax, and
Property
there's
tax.
no income, here, since we're talking about partners, there's no income tax under 62.
Could you help us out with regard to whether or not this is a new interpretation?
So it is not a new interpretation. I mean, the commissioner has been following the same interpretation since the beginning. That's what letter ruling 94-7 states, that the taxation.
That's just the last sentence. It's not really what that letter ruling is about. Are there corporations that have turned over before the 40-year expiration as to which the commissioner has taken this position that the capital gain is taxable?
So I'm not aware of any cases, so that would suggest that they reported the capital gain, and therefore that's the reason why it wasn't audited, that the capital gain was reported when they sold the property.
I'm confused.
I'm not aware of any case.
File taxes every year, right?
I'm sorry?
These corporations file taxes every year that you review.
Mm-hmm. That's correct.
So did they or didn't they?
I'm not aware of any case where a corporation or a partnership sold a property prior to the expiration of the 40 years and did not report the capital gain on
Are you
the
aware of any that did? You
Well, if
phrased
it's
it in the negative. Do you just
I
have
didn't-
no clue whatsoever how this has been done before? Or do you have I mean, we can send you back, and if you have records to this effect.
Well, we have no cases where this issue came up. So that would mean that it was reported correctly. I mean, is it possible that if something was not reported correctly, it wasn't picked up?
Meaning
Of
that
course.
they all converted their properties into private, or, I mean,
Well, they might have kept the project for the 40 years.
It
and
could be
therefore-
that, it could be that they paid the tax.
Exactly, that they reported it correctly and therefore it was not audited, or they had kept the property for the 40 years and therefore afterwards it would be also reported on their return because it's not exempt anymore.
We don't know either way.
we don't know
frankly.
either way. Yeah.
Correct.
And you looked?
Have I looked? No, I have not looked, me
Okay.
personally, as to whether.
Well, not, yeah, okay.
So the board's decision here is consistent with the statutory scheme. I mean, as Justice Wendland was saying, project is defined as including construction and any activities that are related to maintenance and operation of the project. It does not include sale of the project
Why
within the
not?
definition.
Why isn't a sale of a 121A project on account of it being a 121A project? I built a blighted building for the Commonwealth. That's a good thing. I did it to correct the blight and build a 40B project. Why isn't the sale of that and the profits that they make from that on account of it being a 121A project?
So first, it would be in contradiction with another provision of the statute, which is 18D. So 18D is a statutory provision that deals with condominium. Project owners can develop condominiums in order to develop 121A projects. 18D states that if you sell a condominium, this is subject to federal and state tax. And of course, here, state tax would be Massachusetts tax.
You're talking about when they have a dual project, right? When they have something that's a 121A and they also have a separate private sector activity.
Well, I mean, that wouldn't, no, because I mean, if you develop condominium within the 121A project, if you sell those property, then those are subject to taxation. So you can't reconcile the claim that a portion of the project would be subject to tax, but then that the whole project is exempt from taxation.
Why not?
But that would make no sense, because one portion of the project would be taxable.
Yeah.
but then they're saying that that the sale of the whole project is exempt. So you can't reconcile the two. If one is taxable, then the entire thing is taxable.
Well, I mean, wouldn't just the part that's subject to 121A be non-taxable?
Well, there's no splitting of the part of the project. It's like when they sell the whole project, according to the appellant, it's completely exempt. Here we're saying, since here the statute 18D is clear that the sale of a condominium is subject to tax, then it wouldn't make any sense that a portion of the project is taxable, but that the rest of the project is not.
Well, I understand that if it's an all or nothing proposition, that may be true, but does it have to be? I mean, there are ways to figure out what the capital gain attributable to the low-income housing would be.
Well, so I disagree with you. Generally, when it's sold as a whole.
Yes, but there are economic tools that could be used to figure out which portion was low income.
So even if true, it would still disagree that the sale of that the capital gain from the sale of a project is on account of a project. Because, first of all, on account, as the Supreme Court defined in the Ogilvy matter, is very narrowly construed.
It means because, right?
It means because, right? And here, there is no reason to, and 18, the language of on account of, which is found in 18CF, is in that section it says that, you know, in exchange of the 121A exemption, there won't be any property or.
But why what the United States Supreme Court said on account of means in dealing with the relationship between, you know, punitive damages? What does that tell us about this circumstance that we should look to that case to help in the statutory interpretation?
So here is to look at what means on account of.
But why? Why in that circumstance, so divorced from this, does that interpretation matter?
I mean, because it's a Supreme Court's decision, I think it makes sense to look at that decision to figure out what on account of. I think here it doesn't mean that the capital gain derived from the sale of the project is on account of the project, because what that definition, what that section meant was that on account of the income derived from the maintenance and the operation of the project, you have an exemption.
Because we get into the whole dizzying world of proximate causation and but-for causation that this court struggled with Justice Lowy and Justice Kafka recently, if we start doing the because of, right?
Right, that's correct. But here, it should not be, I mean, the on account of in that section should not be read to include the income upon the sale of the project, which is not at all referenced in Section 1, which defines project. Also, the tax exemptions are directly related to the owner's obligation to comply with the statutory provision of 121A. So when the 121A partnerships transferred the property to unrelated buyer, they were released from the statutory and the contractual limitation, limiting their return on investment and the other obligation.
Can I ask you a question about the words of F? It says, in consideration of this tax exemption, the taxpayer will pay the excises, the 121A excises. Did the taxpayer pay the 121A excises for this particular year?
For the year of the sale?
Yes.
I do not know. I do not know.
Isn't that important? Because it says, in consideration of the exemption which you dispute here, they pay the excise taxes. Did they pay the excise
But
taxes?
they did pay the excise tax
Yeah.
on the.
So they've paid the consideration, and you're not giving them, what they're entitled to.
Well, so the excise tax is based on the gross income coming from the rental income, right? So the
Yeah.
capital gain would not be included into that calculation of the excise tax.
That's neither here nor there. They've paid their consideration part of Section F.
That's correct.
And in exchange for that, they get the tax exemption.
They get the tax exemptions.
Yeah.
Once they transfer the property, the tax exemptions are over,
Yeah,
right?
but then we get into the sort of metaphysical, like, when does the, sale occur? And, to me, you lose that argument because the capital gain doesn't happen until the sale. So let's just say there was an accident on the project, right, at the urban development. Who would be liable for that? Until the moment of sale, the liability would go to whom?
Well, until the moment of sale, the liability would go to the owners.
Okay, so up until the sale, the very sale, when they get the check, they're liable. They're on the hook for anything that happens on that project, right?
Well,
So why does it make sense to say that the gain somehow happens after the sale?
Well, I think it's actually simultaneous, right?
Yes, right.
whom
Isn't
does
that a
that
problem
inure?
for you?
I'm sorry?
Why isn't that helpful to the taxpayer?
Because
If it's simultaneous.
When they sold the property, they were no longer under the provision of 121A. They were no longer have to comply with the regulation of 18CA through 18CF, which are the requirement if you have a 121A.
No, but up until the moment of sale, they do. And that's the moment of sale is when they earn the capital gain.
Right, so I'm saying that once they sold the property.
Yeah, but you're talking about afterwards. I want to, that admission that you just made about the simultaneous nature of the sale and the liabilities and I would say the gain. I guess I don't understand the commissioner's position
So
on
we're
that.
saying once it was sold, everything terminates, right?
Yes.
It terminates, the obligation terminates and the benefits terminates at the same time. I mean,
Agreed,
that is our
agreed. What
position.
happens until that very moment?
Well, before they sold, of course, I mean, they were still under the obligation of 18C under 6A, and they were also benefiting from those. But like when they sold it,
Yes.
at that moment,
Yes.
it was transferred. And they no longer were under subject of 121A. They fall under.
What's your reasoning for that? That at the moment of sale, they don't get, they lose the exemption.
So it would go with the same as Section 16, or I believe it's Section 18C relating to the partnership at the moment of when the project is terminated, right? When that is over, then you no longer benefit from the exemption under 121A, and you are no longer under the restriction. And it would make no sense for the legislature to give benefit, to give more benefit to taxpayers who sell their project before
But doesn't,
the 40 years.
what happens to the person who purchases it? Do they have 121A status too?
So
If they keep running this, I mean, because then everything continues. Then there's sort of, if the person who buys it remains in this 121A status in that up to 40-year period, then the project, there's a consistency to it. It's non-taxable or limited taxation for who owns it and who buys it.
So in this circumstance, in this case, they sold the property at year 39.
Say they sold it at year 10, and the person who bought it, would they have 30 years of 121A status?
That's correct. It would not be extended
So
for.
isn't there some level of consistency to saying, okay, the person who sold it was a nonprofit when it was it was a 121A when it was sold, so we're going to treat them under this tax regime, and the people who bought it are going to continue that 121A tax status. But what you're doing is you're converting them into a private, outside of 121A on a sale. Just,
So, I mean, the incentive here it is to get people to invest in those property, right? And to maintain them and to operate them. It's not to sell them.
no,
so
it's
here-
to build them. That's a big risk for someone to take. And to build it, it's not just that they're doing this for income. There are lots of ways of making more income. You're serving a public purpose by building it, right?
But building it and operating it and maintaining it, right? I mean, that is what the definition of project in Section 1.
We don't like to have
relates.
people build buildings they can't sell, right?
Right, and that's correct. But here we want, I mean, as I said, they do have this benefit of like income that is, subject to a much lower tax rate for 40 years. I mean, that's a long time, and it's a really big benefit.
How is it an incentive, though, to have the buildings built if you're going to impose the depreciation that nonetheless isn't available under the Massachusetts tax?
Well, it is under 62, and that's the key point here. If we are saying there's a capital gain is taxable, then automatically you're under 62. You're no longer under 121A. And then because you are under 62, then depreciation were allowable under 62, and whether or not you took them, you still have to include it in the computation.
That's a double whammy is what it is.
All right, it seems the opposite of an incentive.
Right.
It's a complete disincentive.
Well, I would disagree with you, Judge Wendland. I mean, depreciation deductions, I mean, first of all, this court has always, in all the cases that I could find, this court has always stated that if the deduction is allowable, it has to be included in the computation of the basis. And the reason for that, I think, is depreciation deduction are sui generis, as the Supreme Court stated in the Virginian Hotel. And then you have to consider the wear and tear of the building, whether or not the taxpayer was able to benefit it. And they couldn't benefit it in this case because, yes, 121A doesn't provide for depreciation deduction because there's no taxable income to offset those deductions during those 40 years. So that is a reason why 121A doesn't provide the deduction. But here, if you're saying the capital gain is taxable, it's under 62. And 62 provide depreciation deduction, and therefore you have to include it in the calculation of the basis.
Okay.
If you have no further question, I will rest on the brief, and I would ask the court to affirm the decision.